Welcome, everyone. Welcome, everyone, again. I want to now introduce our guest of honor, Dr. Ajunwa. Dr. Ajunwa is an award-winning tenured law professor and author of our book of discussion today, The Quantified Worker, published by Cambridge University Press. At Emory University, she is the Asa Griggs Candler Professor of Law and is the founding director of the AI and the Future of Work program. She's also the Associate Dean for Projects and Partnerships at the university. Prior to Emory, Professor Ajunwa was at the University of North Carolina School of Law, where she was a tenured law professor and the founding director of the Artificial Intelligence Decision-Making Research Program. She's currently a senior correspondence fellow at the Center for the Study of Private Law at Yale School, an affiliate fellow at Yale Law School Information Society Project. She has been a faculty associate at the Berkman Klein Center at Harvard University since 2017. And she was a 2019 recipient of the NSF Career Award and a 2018 recipient of the Derek Bell Award for the Association of American Law Schools. She's the elected member of the American Law Institute and a life fellow of the American Bar Foundation. So we are so lucky to have you today. Thank you so much. And I read your book and I feel like one breath. It was very, very engaging, and I'm certain lots of people here will find so many things to relate to and think about. And my first question to you really is just a very general one, which is, what prompted you to write this book?
Yes. So first, I want to say thank you, a just heartfelt thank you for inviting me uh, for this webinar. I love that there is an organization devoted to women in AI ethics because unfortunately, the voices of women are often sidelined or not recognized or celebrated when it comes to important issues that concern our society. And AI and issues of AI regulation is definitely one of them. So thank you so much for inviting me. I think we also have this connection from Colombia, so it's really great to see you also, Elena. So in terms of how I came to write the book, like everything in life, it's not a straight line, I would say. I was actually at Columbia University doing my doctoral studies in the reentry of formerly incarcerated people. So I was a doctoral student in sociology with a focus on organizational studies. So I was looking at reentry organizations and how they may or may not be the appropriate intervention for formerly incarcerated people to be able to re-enter society and rejoin the workforce. As I was interviewing them, well, they kept saying one thing over and over that finally I had to listen to, which was, I hate computers. And at first, I took that statement to mean, oh, I'm not good with computers or I struggle, but that's not actually what they were saying. As I probed further, I found out that what they were saying was, when I am trying to look for a job as a formerly incarcerated person, what I am encountering is computer-based discrimination or computer-enabled discrimination. What they were saying essentially is, I am encountering having to apply online. I can't walk into a McDonald's or any other, entry level job and meet with the manager and explain my situation. No, I can only apply through an automated system, an AI hiring tool. And when I do that, I hear nothing. It's basically like I never applied, right? I don't hear back. I don't even get a, sorry, no, no thanks. And I thought that was interesting, in a sociological way, because up to that point, I had seen essentially automated systems as being democratic, right? I had seen automated systems as a means of opening up access to as many people as possible. And in fact, I had actually view them also as objective, neutral, maybe. And here, where a group of people telling me, No, these systems are serving as gatekeepers to keep me out of the workforce. So that made me start to research AI hiring systems. And I started to find that actually AI systems as a tool can be used for discrimination, both lawfully and unlawfully. And so that led me to start researching how AI tools have now sort of infiltrated the workplace, the roles that they are playing in the lives of workers, the way that they are changing the working experience, the employment bargain. And that's ultimately what led to the book, all 12 chapters of the book.
Yeah, yeah. And it's so interesting that you're a law professor and you're very well established in that discipline, but you have such an interdisciplinary background. You have a sociology, a PhD, in addition to law, and you bring that to bear in your expose here, right? In your writing, you go back to 100 and even more than 100 now years ago in to another period of very rapid advancement in technology. And you trace how, technology essentially can shift the power at work, right? And you talk about the Industrial Revolution, kind of another time when we saw, the rise of the steam machine and so much technological advancement. And you give us a sense of that, and you focus also on what governments are doing. So can you give us a little taste from your book about that? How did the legal system address these conflicts in the workplace in the late 19th century? And then, at the late 19th, early 20th century, we also see the rise of Taylorism and scientific management, which is really the rise of management as a professional discipline and the rise of managers as a class of people. So can you give us a sense of how these conflicts played out and what was the government's role in adjudicating them? Oh, you've muted yourself for some.
I am so sorry.
No,
Force
no.
of habit in meetings.
Yes,
Um,
yeah.
so yeah, I mean, I think that is such an excellent question because it really pulls in, I think, all the elements of this book. I didn't want this book to just be about what's happening now, right? I didn't want this book to just be about here's a phenomenon, right? And without grounding it, right, in the history, the sociology that produced that phenomenon, right? So I think what I like about my interdisciplinary background as both a lawyer and a sociologist, as a lawyer, I'm interested in knowing what's happening, how do we fix it? And as a sociologist, I'm very interested in knowing why is this happening? How did this come to happen? What in society has enabled this phenomenon to exist? So for
Mm,
me, looking at, the rise of AI tools in the workplace, it really struck me that it is actually part of a larger phenomenon, right? Of quantifying the worker. So you see this, as a historical sort of like dialectical movement, right? Where first you have the division of labor, right? Which is the what is necessary to even have capitalism. And then you have the specialization for more efficiency. And then you have the need for supervision, right? Once you have different people doing different things, then you need someone to supervise them and then also to standardize what's happening, right?
mm,
And then the need for supervision brings in also this need for technologies of supervision, right? So, one of the early technologies of supervision, as we learned from sociology, Bourgeois, is the conveyor belt, right? Because everybody is there in the same factory floor, and then you just need one manager sitting in the office looking down at everyone, or maybe once in a while walking the factory floor. But as you get more and more specialized and everyone can't be there in the same place, then you see how you then have the need for more and more specialized technologies of surveillance, of quantification of what the worker is doing. And then, of course, you get the worker reaction to this. And that worker reaction then in turn spurs legal action. So, for the rise of Taylorism, it was really I think what people miss a lot with Taylorism is they see it as just a manager side philosophy, right? This is a way for the manager to extract the most work from workers or extract the most profit. But that's not actually how Francis Winslow Taylor imagined Taylorism, right? Or really, he would call scientific management. So his vision was that scientific management was going to bring about prosperity for both worker and manager alike because by figuring out scientifically the way to get specific work tasks accomplished, it would enable the worker to work more efficiently and therefore be more productive, but also just be good at their job, which would give them a sense of accomplishment, right? And it also had this idea that you would put workers in jobs that were best suited for them in terms of their skills, their aptitude, etc. So it did have this sort of scientific approach of getting the best work and also the best work conditions for the worker. So there was this idea of prosperity alike, mutual prosperity for workers and managers. So that was scientific management. Now, the way scientific management was applied, which is now more commonly known as Taylorism, sort of ignored that, right? So what you then saw was extreme surveillance of workers in the workplace. You had issues of speed up, where the fastest workers were chosen to set the standard for the rest of the workers, meaning that workers who fell behind were then, punished or, not paid as well or let go. So it really kind of diverged really from Francis Winslow Taylor's initial idea. So fun fact about, Taylor, he was a Quaker and was also an abolitionist. So he had this strong religious conviction about human worth, right? And that actually infused he's writing the scientific management principles. But unfortunately, when his work was put in practice, there was not necessarily that respect accorded to human worth and, to the worth of workers. And there was more of a focus on just efficiency and productivity. And so what you saw then was a huge worker rebellions against the way that Taylorism was being applied, especially when Taylorism was coupled with the use of the Pinkerton detectives. These were private surveillance units that were used to surveil workers, could be, and sometimes used to quell right. They were used to quell strikes or would incite riots where workers would be gravely injured physically for demanding better wages, demanding better work conditions. And that's what led to then the legal movement where you had the Senate hearings about Taylorism, and actually ended up with the United States banning the Pinkerton detectives. So as of now, till date, the Pinkerton detectives cannot operate in any part of government. They still work as private detectives, but they cannot operate as part of government. And that was as a result of the legal battles culminating in the Senate hearings.
Thank
This
you
is
for,
a, I'm sorry, Lee.
no worries. Thank you for walking us through some of the context there. I think something that's really incredibly unique about your book, which I have here, big, huge fan. I think something that's really unique is that it's really grounded in the historical context. I particularly loved that you started it off talking about the description of a slave ship. I thought that was a deeply unique starting point, that and the Roman Empire. And so you talk a bit about the paradox of algorithms as anti-discrimination intervention. And several times, like a theme that I noticed comes up in your book, the legal requirement for burden of proof, it stands in opposition to the black box nature of the algorithms. And so I'm curious if you can talk about the relationship between the informational asymmetry that sets up, and the power imbalance between employers and employees that you kind of elucidate on throughout your book.
Yeah, thanks for that question. And I think, unfortunately, um, sort of maybe a necessary condition of the legal system is that it always lags behind, right? So the legal system does lag behind social developments, but especially lags behind technological developments. So that means that, for example, AI hiring systems do not have any federal regulations for their use. Anyone can create an AI hiring system and deploy it in their workplace without any sort of guidelines, really set guidelines. The EOC had started to attempt to set guidelines, but there are no really true federal rules, hard and fast rules about the design of AI hiring systems, the deployment of those AI hiring systems either. So, that does create a power imbalance and also information imbalance when it comes to employers and workers. So think about how an AI hiring system works. The worker is looking for a job. They encounter a job opening and it says, okay, apply through our AI hiring system. That worker is now compelled to put in or divulge all the information that AI hiring system requires. And the worker is compelled to do this without knowing exactly how that information is going to be used, right? So they just have to trust that all the information they divulge is actually being used lawfully, but they don't actually get to know this because there's, for example, no auditing requirements, right? There are no federal auditing requirements for AI hiring tools. So the employer sort of has all the cards. They hold all the information, right, that the worker is sharing, and they hold all the power in terms of how they will use that information. That is not known to the worker. And in fact, here's an even more insidious issue. The employer can basically decide that they own that data, which means that they can then sell that data with or without the worker's consent. So you as a worker, you think, okay, well, I'm sharing my name, I'm sharing my, email address, I'm sharing my physical address, I'm sharing all my work history. Some applications might even ask you to share your social security number. And I'm sharing all of this with the hope of getting a job. And yes, I get the job, or no, I don't get the job. And you're like, that's the end of it. That's not necessarily the end of it. A big part of it is that sometimes all that information you just shared is then sold to data brokers. And once again, there's no explicit law banning employers from doing this, right? There's no explicit
Yeah.
federal law. So there is this huge information asymmetry and power asymmetry that I think really needs to be addressed by the legal system.
And hence your book, and I and I hope that it does have an effect. But you have so much detail in the book that I would really love to. You have cases and examples that I would love to run quickly through here. And one thing that struck me is that scientific management arose to control the workplace, right? You talked about the the scientific part of it being observations of how long each particular task takes, and then that becomes the standard against which everyone is measured. But now we're seeing much more control beyond just the work
Exactly.
itself, right? And you talk
Right.
about work, the unbounded workplace, right? And that was an interesting term, that the workplace has become unbounded. You touched a little bit on this, but can you talk to us a little bit more about all the different facets in which now we have surveillance beyond just the workplace that's connected to work still?
Yeah. So I think a good way, right, to imagine scientific management as envisioned by Taylor, right, was quantification of work, right? Because Taylor's focus was actually on the work itself. But after that, there were different iterations. And by the time you come to Fordism, you now have not just quantification of the work, but also quantification of the worker. Because with Ford, you had something called the sociological department, which was actually a department of detectives, once again, hired by Ford to surveil his workers and make sure that the workers had attributes, social, physical. So these department would actually basically dictate what workers ate. They wanted them to eat certain foods. It's more American than other foods. They would prohibit workers from smoking, gambling, drinking, all these things. So you have a shift away from quantification of the work itself to quantification of the workers under Fordism. And in Fordism, the workers lived really on a campus. So they were essentially under near constant surveillance, right? And the point I'm trying to make now is that with the advent of these AI technologies that allow for constant and indefatigable surveillance, you don't need human detectives anymore. You just have the technologies to do it. You don't even need to be on a campus anymore. You can be surveilled wherever you are. So a joke I make to my friends is that, oh, we don't work from home. We just live at work. Right? So,
Yeah.
right? So I think that's really where we are getting as a society. We don't work from home, we live at work because really we're doing so much work all the time, everywhere, that the work is the central feature. All right. And frankly, the pandemic made this worse. I have a chapter where I talk a little bit about the pandemic, and the pandemic made this a lot worse because sure, you knew you could be surveilled at work, right? You could have this boundary where, okay, I'm at home, now I'm stepping into work, and okay, I'm ready to be surveilled. I'm ready to have everything I do, scrutinized. But with the pandemic and everybody being at home, right? The work was there too, and so was the surveillance, right? So work became boundless. It wasn't just constrained to the four walls of your office or your factory or your manufacturing plant. The work was now with you in the house. And so was the surveillance.
Yeah, and this reminds me of, previous, I'm so old that I remember a book that came out 20 plus years ago, and it was called, you may know it actually as well. It was called No Collar: The Hidden Cost of the Humane Workplace. And it talked about a particular moment in, history when we had these internet companies that employed a lot of kind of artists, bohemians, that really brought in this sort of ethic into the workplace. They wanted autonomy, they wanted growth, they wanted, self-directed work. But what the book found was that it actually, this kind of autonomy that they were looking for didn't release them from discipline. It actually probably worked even better when you're self-disciplining. You're working 24/7. Every function you go to is work related. You're emotionally invested. You even dream about your work. Your whole self becomes work. And he posed then the question, then, is that the kind of workplace that we really want, where there's really a melding between your work self and any other aspect of yourself is invested at work? And now people have started talking about self-tracking, self-quantification, that we're doing it to ourselves. We know all these watches that you can put to measure a lot of health related data, but also all kinds of other things that produce rankings, produce ratings, right? We're just surrounded by that. And you in your book also talk about, the kind of wearable tech that is now being also required in some workplaces. And you consider that the most insidious form of surveillance, wearable tech. So can you tell us a little bit more about what you learned about all of that and how you think about self-quantification versus worker quantification?
Yeah, I mean, when it comes to tech, I think wearable tech is perhaps the most invasive form of surveillance. You can call it self-monitoring, but it does lend itself to third parties also surveilling the person wearing that tech, right? And when I was researching this book, I found a dizzying array of wearable tech out there. I was actually astounded by the amount of wearable tech and how much it had already infiltrated the workplace. And I mean like from, quote unquote, blue collar work to white collar work. So with the blue collar work, you see wearable tech infiltrating in the form of this is safety tech, right? So that's how it enters. So you see workers who wear exoskeletons, which is a form of wearable tech that measures, for example, when you're lifting, if you're holding yourself in the proper position to be lifting. And you can say, oh, this is great. It'll remind you to lift properly. But what it is also doing, it's collecting data for all the times you're not lifting properly. So if you are injured on the job, guess what? It's now your fault because you were not lifting properly, right? So it's a double-edged sword. And there was all sorts of other types of wearables for white collar work. The most prominent one was Fitbits. And a lot of this tech was being offered as part of workplace wellness programs. And this is offered as a benefit to the worker. It's like, here's a way for you to get a handle on your health. Use this Fitbit to like track your steps, track. But it is also monitoring what you're doing. And newsflash, all that data, where is it going? It is also being sold, right? That data that is being collected is not necessarily under your control as a worker, and in fact can be sold by third-party brokers for people for insurance companies. So for people can be denied certain types of health insurance, or I'm sorry, certain terms of like long-term insurance, life insurance, based on health related data that's coming out of this wearable tech. So it is, imperative, I think, that we also think about how we regulate these wearable tech, right? Especially in the workplace, and also, especially, or even more importantly, the data that is coming out of them. Who has access to that data? Who has control of that data? Should that data be able to be sold without the knowledge and consent of the person that generated that data? These are all still outstanding legal questions.
Yeah, and this is to me personally such a big benefit in reading your book because I rarely otherwise read legal stuff. And I mostly tend to read, social science books, but this is where to me it was so illuminating in learning about the legal pitfalls and what has already been done also. And so I want you to tell everyone here about some of the minimal regulation that might have come out already, such as, for example, the Genetic Information Non-Discrimination Act, or GINA for short. Can you tell us a little bit more about how that came about and what it entails? And what are its deficiencies, let's say?
Right. So the Genetic Information Non-Discrimination Act actually came about because of the mapping of the human genome was completed. So that mapping, I think, took about 10 plus years to map the entire human genome. As the technology obviously came about to be able to actually do that. But the scientists actually who did this, they realized, oh, wow, right? Now that we have this technology, it does open up new issues. Because if we are able to map the entire human genome, then your privacy is at risk. There are other stuff at risk. Your ability to get health insurance, all of that could be at risk because someone could just get a strand of your hair and essentially know all your propensities and use those against you, your propensities for disease. Because, and I say this for our international attendees, in the US, we don't have a single payer or universal health care. We are dependent on private health insurance. And those companies are for profit. So they have an incentive to deny health insurance coverage to individuals that may be more genetically predisposed to disease. So now that you have the ability to figure out actually who those individuals are, right? The scientists realized and called upon Congress to, put laws in place to prevent this, to essentially prevent genetic discrimination, which would then create a class of people that would not have insurance. So that's how the genetic information was, written into law in 2008, put into practice in 2009. Now, the Genetic Information Non-Discrimination Act, short is GINA, prohibits discrimination on two fronts. So Title I prohibits discrimination for health insurance, right? I'll come back to the loopholes a little bit later, right? But just know it prohibits people from being discriminated against, being denied health insurance because they have a genetic propensity for disease. Title II prohibits discrimination by employers for people who might have a genetic propensity for disease. Why? Why employers mentioned here? Well, for our foreign attendees, employers are actually the middlemen for health insurance in the United States. Because once again, we don't have universal health care. The method through which most people, the vast majority of people in the United States, get health insurance is through their employment, is through their employer. So employers now also have, right, a financial interest in not hiring people who might have propensity for diseases, that would be costly for their health insurance, right? So that would give employers really an incentive to discriminate against those people and not hire them. So GINA prohibits that in Title II. Now, there are several key loopholes that I think are important to understand. So the first part, I told you, GINA prohibits discrimination for health insurance. GINA does not prohibit discrimination for long-term care insurance, disability insurance, and life insurance. So if the insurance company does know that you have a propensity for disease or, whether chronic or acute, that would require you to need long-term care or need disability insurance, or maybe, have to cash in on your life insurance earlier, or your survivors, then they can deny you those three types of insurance lawfully. That is a loophole in GINA, right? So that's the first part. The second part with the employers, so the employers can't discriminate against you using your genetic information, right? Now, with the advent of technology, there's a question of what is genetic information, right? Because now with AI, you can actually make, how do you say it? You can deduce things, right? Based on triangulating different, information to come to a genetic picture of the person. So this is to say, I no longer have to take a strand of your hair and test it to now figure out that you might have a genetic propensity for certain diseases. I can actually deduce this from gathering all the different health data you have out there and putting them together. Or I don't have to even put them together. AI can put them together for me. So that's an issue. So GINA does have these glaring loopholes, right? It does.
Yeah, that is very important to know, because my next question was going to be, so genetic information to your employer, you can refuse to give that, right? And that's also a big question. Actually, when can you refuse and when can you technically refuse, but really you have to do it. But then the other bigger question is also that even if you refuse, yeah, there's so much data out there that that can be deduced, as you said.
Right.
Um,
So here's the issue. You can refuse to give genetic information to your employer. And in fact, Gina says it is unlawful for your employer to ask you for genetic information, but there's a loophole, right? So generally, it is unlawful for your employer to ask you for genetic information. However, they can, if you voluntarily, and I'm going to put voluntarily in quotes here, if you voluntarily sign up for a workplace wellness program, they can collect your genetic information as part of that workplace wellness program.
this is where the wellness programs
Exactly. That's
come
where they
in.
come in. Yeah.
Mhm.
So this is a carve out from GINA. So the Affordable Care Act, right, actually is the one that introduced this carve out from GINA for wellness programs.
So this is very important to me that, you know, it is so difficult to rebel, if you wish, against this. Because if we think back 100 years ago to Taylorism, right, workers found ways to sabotage the scientific management methods. And usually they did that by actually really doing only exactly what the method prescribed and nothing else. And it turned out it was impossible to prescribe every single step. And if you actually followed the prescription, work couldn't be done. So they demonstrated their need of autonomy in some ways. But now it has become so difficult to disentangle work from other activities, especially those that benefit you, such as wellness programs, that is much more difficult. So let's focus now on the real meat of your book, which is the legal framework that you propose, which I find very fascinating. I learned a lot from that because these are questions that people have really struggled for a long time with, right? Do we want a workplace that's very democratic, that, you know, allows for workers to participate in decision making, that has some sort of committees for that, that are worker collectives perhaps? Or do we want a very efficient workplace where we have, you know, strict lines of control and hierarchies and so on? And you base your thinking in the theory of justice by John Rawls. So for the benefit of everyone here, can you run us very quickly, if, you know, as much as you can, through why you chose that as your framework? And then, okay, then I'll ask you other questions, but yes.
Yeah, so John Rawls, you know, is perhaps I would say the most famous legal philosopher in American legal philosopher. And also he was a moral legal philosopher. So he was preoccupied with the idea of not just like, okay, you know, efficiency or, you know, business and, business, uh, productivity or things like that, but more about how do we create a just society? Like, how do we organize the legal systems to ensure that it works for the benefit of all or most people, right? So from my point of view, I thought Rawls was the best person to sort of pay attention to in terms of what he's talking about when it comes to thinking about the regulations that should, flow for controlling this AI systems. Because right now, the way we're looking at these AI systems is, are they efficient? Do they work to produce X result? But what Rawls is challenging us to do is think about how are these, laws that we're putting into place, how are they shaping society? So not just about efficiency or having things work, but a bigger vision. Are these laws helping to co-create the society that we want, right? Are these laws helping to create what he sees as a moral society, right? Where we are invested in people as human beings. We are recognizing the personhood of all people, right? Not just a subset. So for me, I was struck, especially when I would speak with like computer scientists or, AI developers, they seem to be very stuck on a very narrow goal, which is, does my AI technology work X amount of time? Like, is this accurate 98% of the time? I'm like, okay, if it's accurate 98% of the time, but that 2% of the time that it's not accurate, it's for the same group of people. Is that okay? Right? So think about it. The United States population is 2%, about 2% Native American. So if we had an AI product that worked for 98% of people, but not all the 2% Native Americans, would we be okay with that? No, we shouldn't be okay with that, like a whole group of people being excluded. So Rawls' theory of justice really is about this. When you're creating laws, you have to think about the person who would be disadvantaged, who loses, not just who benefits, right? So, and he's asking you to put on a veil of ignorance where you don't know which camp you're in. So you as a lawmaker, you should imagine, well, I could be in the disadvantaged group. I don't know if I'm in the advantage or disadvantage group. So when I'm making the law, I need to actually make sure that the law would benefit also this disadvantaged group. Because under my veil of ignorance, I don't know if that's me. That could be me. Do you see? So for me, I think that is a good way to think about governing these AI technologies. Not just to think about, oh, are they efficient X amount of time, but to think about, are we actually ensuring that they are working well for everyone, including the disadvantaged? So paying special attention to vulnerable groups, vulnerable populations. So I just to illustrate why this is important. This is important because it actually, once you focus on the most vulnerable groups, you actually end up benefiting the biggest amount of people. And here's a true to life example of this. So when I started researching AI hiring tools, my focus was on formerly incarcerated, right? But then when I did a field study with a co-author where we went on the website on the AI hiring tool for a major retail brand, right? I wouldn't name the brand because I don't want to get sued, but huge one, you know it, you've shopped there. So we are applying for a job, right? So we thought, oh, well, why don't we take on different personas? Right? And see how this hiring system would work. So I took on the persona, I'm a mom, right? And I'm essentially a stay-at-home mom, but I want to work because now my kids are in school, but they're in school, right, in America from 9 a.m. to like, let's say 2:30 p.m., right? And there's usually no free after school. I would have to pay for after school. So I would want to only work from 9 p.m. to 2:30 p.m. So I am going to apply for what? Part-time jobs. So I go on this retail, AI hiring tool. I apply for a part-time job. Do you know what I found? I found that even for a part-time job, when I put in my availability, my shortened availability, I could not even submit my application. The system would not allow me to submit my application. I kept getting an error just because I had truncated hours. I did all sorts of things. I was like, okay, maybe I have an error here. I switched all sorts of things. I could not even submit the application until I went back and I have unlimited availability. Same application, one difference, immediately submitted.
Yeah, and it gives you a technical error. It doesn't tell you.
Technical error. So it doesn't tell me what they're actually doing, right? So that's that information asymmetry. Like if I'm, you know, just an average mom, I don't know that this isn't a real technical error. I just give up in frustration. And guess what? Because I gave up in frustration and no application was ever submitted, there's no record that I was denied a job there.
Totally.
So they've algorithmically denied me, but there's no record. So they're able to get around, right? That having that record of denying me a job. You
Yeah.
see,
Yeah.
right.
Yeah. Mhm.
So, so my point is these systems that were, you know, perhaps created to keep out certain folks, it can be expanded to keep out all kinds of different groups, right? So regulating the systems to make sure that they're actually not working in these insidious ways is going to help a wide group of people.
Yeah. And I think you go much more, you delve even further into kind of more tricky questions. And you talk about two different approaches to the way we think about a good workplace. One is the non-interference approach, and the other is the non-domination approach. And
Right.
if I got it right, you know, the non-interference is really derived from Nguyen Hsieh's approach. You call this workplace republicanism, right? So it's not democracy, it's republicanism. And the other one is non-domination, which is based on Philippe Petit. So can you briefly tell us the difference between these two approaches and which one you endorse and why?
So, I mean, I'm always going to be about the non-domination approach, right? Because that's, I think, ultimately what we humans care about. We humans, we have a visceral, right, dislike, or I would say hatred for feeling that our personhood is being infringed upon in any way, right? If you think about it, employment is a bargain, right? And the bargain isn't I give you my person. The bargain is I give you my labor for X amount of money. So when the other side starts to take more than your labor, right? Then it becomes domination. Then it exceeds the employment bargain, right? Because we want to, yes, work to specification and etc., but we still want to retain some element of autonomy, right? Some element of discretion. We still want to not feel surveilled 24/7 because that is all tied up into feeling like a person as opposed to a thing, a cog in the corporation. So I think the key is having non-domination. Now, I do think also that this republicanism approach is important for certain workplaces because workers want to have even more say, right, in terms of like how the workplace works. And that's, I think, important when you have a workplace where you have more knowledge workers and there's a little bit more of a divorce between the actual day-to-day and the manager. So imagine your manager coming to tell you, you kind of alluded to that before. So a lot of times, you know, bad managers actually make the work worse because they tell you to do something in a way that sounds good, but in practice doesn't actually work, right? Because, you know, as organizational theory tells us, workers develop something called practical drift. There's a way that work has maybe always been done, or maybe theoretically work should be done. But workers on the ground, the workers who are actually doing the work, they quickly figure out through trial and error some shortcuts, some quicker ways, some more efficient ways. That's called practical drift. And organizational theory tells us you actually want to allow for this because that's actually how you're going to get efficient, productive work, right?
Yeah, yeah, exactly. I mean, this has been critiqued also this kind of separation of the doing from the knowing, right? That the managers are the ones who know and the workers are the ones who do. This is kind of an old way of thinking about it. And I think, with the newer organizational theory, there was a lot of talk about the very good things like collaboration and learning from doing and, all of those things, that it seems to run against this automation and surveillance. So it's a very interesting disjointed kind of coexistence of these different drives, or because you could say one is only rhetorical, what's really happening is automation, but I think on the ground you'll see kind of both that run against each other sometimes. But I wanted to ask you a little bit more about the non-interference approach. Why is that a little bit limited in your view? Or is it limited and it maybe it's not, but it's just fit better for, you started saying it's better fit for larger organizations in which you do have this kind of separation of people who do the work and managers, then maybe the framework of non-interference into work will be better. Do you want to say a little bit more about this difference between non-domination and non-interference? Is there a difference, or is it essentially the same thing?
I mean, I think there's a slight difference. I think non-interference does, I think, envision more worker voice, I would say. I don't even want to say that, more worker direction, I would say. So I would say you still have worker voice in the non-domination. It's not that worker voice is gone, right? Because worker voice is telling you the limits of, the boundaries. There's a boundary, a delineated boundary there. I think non-interference is calling for more sort of worker input into that, at least as I understand it. These are not my theories. So I apologize to the proponents if I'm getting the theories incorrect. But to be quite honest, I think at the end of the day, different workplaces are going to need slightly different models. I don't think you can essentially have a one-size-fit model for all workplaces. I think you have to think about general principles, right? So I think the general principle of recognizing worker personhood, the general principle of recognizing non-domination of workers, as in workers, the bargain is for their labor, not for, like, let's say, their political opinions, not, you know what I mean? Not for, let's say, their lifestyle, right? That's not part of the, employment bargain. The general recognition of, the fact that we have a solidarity as humans, such that we're not going to dismiss people just because they have a propensity for disease. I think somebody mentioned in the chat, we all have a propensity for disease, right? As human beings, as mortals, right? It just when, like, we just have different timelines, right? And obviously different diseases that we have a propensity for, but as human beings, we all have a propensity. So just having that solidarity of saying, okay, we all have this, and we're not just going to dismiss someone who could very well still have so much to contribute to society just because they have this particular propensity, right? And this is something I think that in the US we struggle to I think activate, right, that solidarity, that sort of empathy, versus other places. I talk about, I think I talk about this in the wellness chapter, right? We have in the US this idea of, rugged individualism, right? Whereas other places like France, they do have a solidarity where they're like, okay, I'm not sick, but I'm okay paying into a system that helps people that are sick, because maybe one day I'll get sick. So there's a solidarity there. Or even if I don't get sick, I just want to live in a society where people are not bankrupt from, health bills, right? Whereas in the US, we have this idea of rugged individualism of, I'm not sick, why do I have to pay for you when you're sick? Or even if I get sick, I'm going to make sure I have enough money to pay for myself. And I don't care about, if you are able to get enough money to pay for yourself. So these are two different philosophies. And I think, we need to realize what that means, right? As a society, what it means for us in the US is the number one leading cause of bankruptcy. It's not people opening up ill-advised businesses. No, it's actually people getting sick. The number one cause of bankruptcies in the US is your health hospitalization bills. It's people getting cancer and not being able to pay for all their cancer treatments, right? It's people getting a catastrophic illness. And then after they've spent years battling that illness, they now find out they're very much in debt, which they can't dig themselves out of. That's the number one cause of bankruptcy in the US.
That's actually a beautiful segue into my next question. I find that, the regulation landscape and historical context that you present in the book is often US specific. Particularly, you talk about Taylorism being informed by a Protestant work ethic and the rugged individualist outlook that we have in the West, and particularly the diffusion of the boundary between the private sphere and the professional sphere. And I think that's something that is overall, it paints quite a bleak future for the nature of work in the US. And I'm curious, how many of these changes of the nature of work are US specific? And have you noted any international regulations that would be possible to emulate here in the US?
Right. So yeah. So, the book is certainly focused on the United States because I feel like that's my area of expertise, both as a sociologist and as a lawyer. My training as in law is just in US law. That being said, I do see some of the same phenomenon starting to creep into other jurisdictions as well. There's been talks, I think somebody even mentioned it in the chat, some European countries wanting to do away, right, with the universal healthcare, wanting to move to a private model. There's certainly been talks of that by not just one country, even several countries. But I think when it comes to the future of work, I think the US, I worry, is particularly bleak if changes are not made. I mean, I think that with the EU system, they actually have enumerated rights in the EU AI Act for workers, right? And some of those rights call for audits, for example. Hiring systems are seen as high risk and therefore have to be audited. We don't have any of that in the US, right? We don't have that sort of, I think, larger protective instinct for workers. And I think we really, really need to develop that. It is heartening for me, at least, that some municipalities, so New York City, for example, passed an audit bill for all automated decision-making systems, including hiring systems. Now, we don't know exactly how this is going to work in practice. It still remains to be seen how exactly it works in practice, but it is heartening that there is at least a thought for that and an actual like legal action for that in New York City. And similarly, California also has some protective laws for workers when it comes to the use of AI in the workplace.
In terms of the observation that you made in your book around the breakdown of the boundary between the professional sphere and the private one, I'm curious, something that you referenced Caroline Criado's Invisible Woman in the book, which really emphasizes how labor in the domestic sphere goes unpaid and unseen. And I'm curious if you see, or how do you envision the changes around the nature of work impacting the domestic sphere where the labor is already undervalued and unseen?
Right. No, that's an excellent question. And for me, I actually think the greater emphasis on quantification is going to hurt, um, frankly, more women than anyone else.
Mm.
Because think about all the sort of gendered ways women have been socialized to work. So if in the workplace, for example, I decide I'm not necessarily going to try to get to know my workers or my employees, I'm just going to judge them based on, how many emails are they writing per day, right? How many calls are they making per day? Like how many, I don't know, articles are they writing per month or whatever? Like, I'm just judging my employees on quantifiable things. What am I going to miss? I'm going to miss the worker that doesn't send emails, but just goes up and talks to their employee, to their fellow employee, right? That worker that maybe isn't writing an article every month, but is actually helping others, right? So they write an article maybe once every 3-4 months, but then they're actually so available to speak with students, to help their fellow, professors or whatever, right? So I'm missing all these things that are non-quantifiable, all this, frankly, for lack of a better word, emotional labor, right, that women have been socialized to do, this labor that's very, very gendered. So I do worry that yes, a greater focus on quantification is going to harm, especially women when it comes down to it.
Thank you so much. I think we can continue talking, but we have audience members, I believe, who would like to ask some questions in the remaining time as well. So we'll stop recording, I think, here so that people can feel free to post any question that they would like to answer. And for those of